You're going to become like 62 and you want to go into the spree program, but you also have a sibling that you would like to have the apartment, get the apartment later on. Is that
I live on the Upper West Side. I've got 2 children, a rent-stabilized apartment. I've been there for 35 years. I was wondering how hard it would be to get their names on the lease.
This new law that they passed is that the nephews cannot, or the aunts and so forth, cannot succeed, succession rights. He told me I have 30 days to get out.
Succession rights, one of the most important issues for the 2 million residents of rent-stabilized apartments in New York City. Here's how it works. Your mother's name is on the lease, she moves out of the state, and you continue to live there. Do you have the right to a lease in your name? What if you are the niece of the tenant? What if you are not married but just are in a committed relationship with the tenant? If the tenant dies, do you have succession rights? I have answered these questions for tenants live on the air for years. In this show, we take a look back at those phone calls and at one of the most hotly contested areas of housing law today.
Yes, hello. I have a question. I live on the Upper West Side. I've got 2 children, a rent-stabilized apartment. I've been there for 35 years. I was wondering how hard it would be to get their names on the lease.
So how long have your 18-year-old and your 19-year-old lived in the apartment?
I'd say about 2 months.
Okay, and so they would have to live there for 2 years prior to you moving out in order to get succession rights. But that wasn't your question. Your question was, how can I get my children on my rent-stabilized lease, where I've lived in the Upper West Side for 35 years? And the answer is that you cannot, because that's in a sense not the way it's done. If you have a lease tenant, that lease tenant has children, and those children live in the apartment. What it is those children are not considered co-tenants. They have every right to be in a rent-stabilized apartment. No one can throw them out or anything like that just because they're not on the lease. But they are not considered the lease tenants. But what do they get? They get, if you happen to die or move out, perhaps your kids are getting big now, so maybe they'll just throw you out. If in fact that happens, your children, your family members would have succession rights to the apartment if they meet certain criteria, which in a nutshell means they have to live in the apartment with you for 2 years prior to your passing away or moving out. Send the landlord a certified letter which states, I want to inform you, and please put this in the tenant file, of who lives in the apartment, and state the names of the people, their relationship to you, if any, and their ages. You put it in the letter as a way of making, putting it on the record who lives in the apartment, because if they lived in that apartment for 2 years, they get succession rights. If you go to manhattanfirm.com, and you click on housing information, and you go to rent stabilization and rent control, I have a fact sheet that explains your children's rights. That's right here under succession rights. So you go to my succession rights fact sheet, and it gives you the statutory basis of succession rights for rent stabilized apartments that I just explained. Also, this covers not just rent stabilized apartments, it covers rent controlled apartments. It covers not just people who are heterosexual and married. It covers people who are homosexual and are in long-term relationships. It covers not only children, but it covers, I think that it covers grandchildren. And it covers a lot of people who are in what the court might define the non-traditional family relationship. So it doesn't have to be blood relatives. It might be somebody who the two of you consider that you live as if you're husband and wife, or as if you're a brother and sister or a father and son or whatever.
Experience Filipino dance, martial arts, and legend from New York's famous nonprofit dance troupe, Kinding Sindao. Learn more at kindingsindao.org.
The reason for the breakup, who was the cause of the breakup, plays no part in the determination of equitable distribution or custody, for that matter, or child support. There is no punitive aspect to the determination made by the judge. See, the bottom line in most matrimonial actions, once you get over the emotional issues of the breakup and the difficulties with socially and the child custody and things like that, the bottom line is financial. It's very important and it's beneficial to all clients to remain as unemotional as they can when dealing with financial issues.
Succession rights is not the same as getting on the lease. Succession means that a daughter gets the lease when the mother leaves, but the daughter does not get on the lease while the mother is still there. That means that someday, in a court, many years from now, she may have to prove that she lived there for the requisite period of time. Hear this next call.
I have a question. If you have a rent-stabilized apartment and you're going to become like 62 and you want to go into the spree program, but you also have a sibling that you would like to have the apartment, get the apartment later on, is that a possibility or not?
Absolutely. If you are over 62 and you get into the SCREE program and your apartment is rent stabilized, if you're, that has no effect on the ability of your relative to get succession rights. Does your relative live with you?
Yes.
Okay, and how long has...
over 2 years.
Over 2 years?
Time, yeah.
Ooh, you've been to my website. You know all these standards. You know that the relative has to be living with you for 2 years.
I'm trying to get one.
Okay, well you're doing pretty good for being an analog kind of gal.
Thank you.
So anyway, so you're going to be over 62. You're going to apply for the SCREE program.
Right.
And now, have you ever gotten any request by the landlord by mail to inform him as to who else is living in the apartment?
No, never.
Good. Okay. The rule is that he has the right to ask who else is living in the apartment, and but you don't have any obligation unless he asks to provide that information. However, if you move out of your apartment, your relative would get the succession rights. And I'm sorry, what type of relative is this again?
Daughter.
Daughter. Yeah, it's pretty much a lock, especially if she can prove that she's lived there for more than 2 years.
Right.
The only snag is if the daughter lives, has a connection to an address someplace else. Is that the case?
When you say have a connection, she has a boyfriend. But there's nothing in writing in terms of another connection. You know what I'm saying?
Okay. And well, does she receive any mail
no.
over the other place? Where does she receive her W-2s?
At our address.
Okay, so all the official
our address, the bank statements, everything.
Then you're doing fairly well.
Good.
You know. And so good luck to you. I think that you have a good situation. You're going to get SCREE. I'm going to describe to the public what SCREE is, and then your daughter most likely has succession rights. You don't have to do anything
She'll come
further
to you
about
when it's time.
Absolutely, and you know where to find me.
Yes, thank you. Bye.
Thank you. And so
Visit our non-commercial website at manhattanfirm.com/TV. Landlords and tenants have fought over every aspect of the rent stabilization code in the courts and the committee rooms of this state. Since only family members get succession rights, one of the big issues is, what is a family? Hear this next call.
My uncle passed away just a week ago.
I see.
And so, and now I want to, to see. I received a letter from the landlord and told me that I do not qualify to.
What was his theory?
He told me that about this new law that they passed is that the nephews cannot or the aunts and so forth cannot secede, succession rights. And
did he mention the law?
He did not mention it, but he told me I have 30 days to get out, to vacate the apartment.
Did he give you a 30-day notice?
Yes, he did.
The landlord is totally wrong because, yes, they took the nephews out of the traditional family member thing, but that doesn't mean there's a bar to nephews succeeding to the apartment under a non-traditional family member status. For many years, it's been the case that traditional family members who have lived in a rent-controlled or rent-stabilized apartment for 2 years prior to the death of the tenant of record could succeed to the apartment. Now, a few years back, the law allowed for so-called non-traditional family members to also succeed. In other words, if you live with the tenant of record in a way that is equivalent to a family relationship, then you can succeed to the apartment as well if you have lived there 2 years prior to the death of the tenant of record. And that was good news for domestic partners of all types and other types of family situations where people weren't really related, but they really lived together like they were family. And in 1997, in the Rent Regulation Reform Act of 1997, they said, well, for the traditional family members, we're going to cut out the nephews.
Yeah, that's something.
So you're no longer part of the family, according to the rent stabilization. And they dropped the nephews from the traditional family member list. However, you still qualify as a non-traditional family member. The only thing I can see as a roadblock, potentially, is if there's something that I don't know about your 2 years co-residency prior to the death of your uncle. Now, like, do you live anywhere else? In other words, do you have a second home someplace?
No, I live right there for the 45 years.
Okay, that's what I want to hear. And usually when it's a winter case, that's exactly what they say. Some people will go, oh, no, I live there, but I also have this other house in Long Island or whatever.
I know every inch of the apartment, the block, or whatever.
If a tenant dies and you want to succeed to the apartment, there's a good chance that you're going to find yourself in court. Now, battles over succession rights can be drawn out and complicated, and when adversaries deal with each other in court, they follow the rule of confirm and verify. The next caller is at risk of eviction at any time. The landlord stated that he and his sister can remain in the apartment for an additional 5 months over the phone, even though the tenant received a marshal's notice that the tenant would be evicted within 6 days. What would you rely on, a marshal's notice or the landlord's verbal promise? You decide.
My sister and I had the lease under our mother's name, and the landlord wouldn't put it on our name after she passed on. And what happened was they took us to court for the same issue, a legal sublet, which while my sister was under treatment for depression, I had lent it to some friends. So after that, we went to court and we made a settlement for 1 year, which ended on December 31st in 2004. However, since we're currently finishing a lawsuit, a wrongful death suit, basically what happened was they extended it for a couple of months. And now they've extended it until late April. But I wanted to know if there's any recourse on our part since the settlement has already expired.
Well, I don't know. Well, most likely you don't have a chance, and I'll tell you why. If you made a settlement in housing court, and were you represented by an attorney at that time?
Yes, we were.
And then and that settlement was an entire year ago. If in fact you had cold feet about the settlement, you would have had to have brought brought the case back to court to vacate that settlement within a very short time period. I would say about 24 to 72 hours after you signed the stipulation. It seems that you got 1 year to live in the apartment, and that was part of the settlement. And was there some type of monetary payment involved as well?
Well, I had to pay about 2 months arrears, and we paid the monthly rent, which is basically really low, and at the student dorm they can pretty much triple the income afterwards.
I believe it.
Yeah.
And so you had reviewed for us a couple of issues that were going on in the case while the trial was going on. One of them, of course, being that the lease wasn't in your name. That's not a problem because it was in your mother's name, and they were refusing to place you on the lease. It is a rent-stabilized apartment. Certainly you had the opportunity to succeed to the apartment. Another problem, which probably was the more difficult problem, was the issue of your being absent from the apartment for a while, the sister having her own issues to deal with, also absent, and then you were lending the apartment to some friends. There was probably the major weakness in your case.
Yeah.
And so you did a really good job, though, because...
1 year is good?
Well, it's not... I'll say it's not bad.
Okay.
And I'll tell you why you did a good job. First of all, there's in housing court, there's winning and there's losing. And if you play your cards totally wrong, the marshal's at your door and you're getting evicted. However, when the chips are down, and this is true for both landlords and tenants in housing court, when the chips are down and when you are low, there's always a possibility to find some type of settlement, some type of resolution. You're not going to get 100% because, after all, you're losing. But it's better than an eviction. And so what did you get? You got an extra year in that apartment. And what is the rent for the apartment?
Well, the rent is really low. It's about $580.
Mm-hmm. And how large is it?
Naturally, the location.
What did the settlement state about if you happen to hold over in the apartment past the term of the settlement?
And there was no indication of that. It was just handwritten on the court. The lawyer wrote down that we pay the arrears and vacate the premise by December of 04. Last month, at the end of January, they sent us an eviction notice, and I called their attorney, and he spoke to our attorney that's representing us for something that's entirely different. That he just spoke to him and said that we'd need a couple of extra months. And the attorney said, okay, how about until the end of April? Which is good, but at the same time, I wanted to know if we could obtain some kind of, go down to the court and through a judge obtain something more concrete. Because
how does your attorney know that you have an extension until April? Is this in writing?
No, they just verbally agreed. Since I know the building manager, that's what I don't like.
Okay. Well, you are in limbo.
Pretty much, yeah.
You are in limbo because what you did is you received in writing a marshal's notice of eviction. And somebody, I don't know who, spoke to your attorney or spoke to you and said, oh, no, forget about that. You can live there until April.
Yeah, the lawyer from the building manager.
And that's trouble.
Yeah,
that's trouble because you cannot orally modify what has already been placed in writing for something that important. If you have a piece of paper that says you are going to be evicted, and then that is in writing, and then there's an oral communication saying you are not going to be evicted. The problem is that there's all types of misunderstandings and miscommunications that could have went down regarding this stay until April thing. So you are in real limbo. I think I would suggest going back to your attorney to clarify specifically what is going on so that you don't have like some major surprise. At the same time, I think that you could explore with your lawyer the options of can you actually live there longer or further, and it seemed that this is your second request for an extension, right?
Yeah.
And so, really, it's almost at the landlord's discretion, and you don't know whether the landlord will grant it or not. If they do, it's probably based on their own convenience. You know, maybe they're just simply waiting for the beginning of the next school year.
Right. That's probably right.
And so, I wish you a lot of luck. I hope everything works out for you. But I would say on Monday, give a call to a lawyer. Say, yeah, it's not in writing, so I'm very concerned about it. Just tell me what the substance of the conversation was, and so forth. Now, if this was an agreement between lawyers, first of all, I'll make an agreement with a lawyer similar to this.
Right.
But I'd have to know that lawyer.
Yeah.
I mean, even if a judge tells me something, I have to know that judge.
Yeah.
Because if it's not in writing, you have to know who you're dealing with, or else, you know, or else you have to verify everything.
Well, it's pretty much that since they know that my sister's on disability, so I guess they understand that they have to be, you know, generous, or at least not so harsh.
I have no idea. Maybe if there was a worsening situation with your sister, yeah, the court might grant some type of extension.
Okay.
So if we're talking about something medical, something mental, or something physical, then there's a greater chance that you'll get an extension in court. And so I hope that's the case, and I wish you a lot of luck.
Okay, thank you very much.
All right.
I hope you've enjoyed this show on succession rights, if enjoy is the word for it. If these calls show anything, it is that it pays to know the rules far in advance. Because if you wait until you get to court, it may be too late. I'm Stephen Castro.
Program policies allow us to recognize the following sponsors.